We'll start right about 3, since we were going to stream it. And we'll be able to record it today, so if you need to look back or whatever, it'll be recorded and on our website. Because we got our technical person, pastors here. We had technical difficulties last time.
It was a year.
Yes, it
Just wraps around.
It is not on, so you can just push that button and turn it on.
Gotta watch it. Y'all are interrupting my Sunday afternoon nap. But it's okay. I'll take over the here. Yeah. Richard's head's little. I think I got the back. He's got a little pea head. He got a big old mountain head.
How are you?
Did you run her off? Did you run her off?
Don't have no idea. She's leaving.
No control over where that thing goes at the end. Go run over and tell him, please help him. Well, good afternoon. Thank y'all for joining us today. So we have our mics on, so hopefully through the speakers you can hear what we're saying. If we need to speak up, please let us know. Just raise your hands, let us know what you need. And thank y'all for coming out today. I am going to go ahead and introduce Branson Pethel. He is a lawyer in Salisbury. Did his undergraduate at Catawba and his training jurisdiction at Wake Forest. I'll get it right here in a minute. But we're very pleased to welcome him out today for our discussion. And I'm going to start off with just a little bit of on the medical side around planning for end of life. And that's really what we're talking about today. How do we plan for end of life? What are those things that you need to know? And we're basing this around dementia, but you can apply this to any long-term chronic health condition, even things like cancer, heart failure, or other conditions. But there are a number of things that we need to know as we're starting to plan for end of life around what is possible, what can we do, what do we talk about, how do you talk to your medical professional about it, and then when is the right time to seek out assistance in a legal form. So there's very big differences between what we do as far as that planning is concerned. Now, I don't know how many of you have ever seen one of these two forms. Good, so a few. I'm going to take a couple of sheets and let you guys pass them around to see what they are. And we're going to talk a little bit about them. But they're very important forms for us because these are approved through the Department of Health and Human Services of North Carolina. These are two forms that work in concert with one another, but are used for very different purposes. So we're going to talk about this one first. Okay, we call this the goldenrod form because it's goldenrod in color. Some folks will call it a yellow form and an ENR form, right? So this form right here is what we fill out. The patient says, look, I'm at that point where if you pop on my chest, I'm going to come back and haunt you. Please don't do that to me. We're going to fill out one of these forms. And if you place this in a very prominent location in your home, and I tell people, I say, put it in a sleeve and put it on your refrigerator, right? And then in some cases under hospice care, we may even have them mounted on the front door, the main entry door. And this is one of two forms. So there's the goldenrod and there's the pink form. That if EMS sees this, they will not do resuscitation. If you do not have either one of these forms, they do resuscitation. Okay? They're going to push on your chest. They're going to intubate you. They're going to do what they need to do to try and revive before they transport. Okay? So these two forms, again, have very similar information, but this is just the do not resuscitate form. There's a second form that goes along with it, and there's a couple of different ways that we fill those out, but that's on my side, not on your side. But it talks about common law versus something that's written, right? So a patient may decide, hey, I want to go and get a legal form completed. And so there are two different types. There's one called a living will and one called a healthcare power of attorney. Now, both of those forms are readily available. You can get them off the internet. North Carolina Department of Health and Human Services has them. Novant has them. Atrium has them. We have them listed on our website.
Secretary of State?
Yep. So we have a lot of places that those forms are available to anyone for free. Okay? Living will basically says, here are my wishes. If X happens, do this, or don't do this. Healthcare power of attorney says, if I can't make the decision for whatever reason, this is my person. This is who you go to talk to. Or, here's the alternate if that person's not available, right? So there'll be a primary and there'll be a secondary. Now, state law, best I understand it, and Branson can correct me if I'm wrong here, but state law says it's the closest living relative. If there are no forms, it's the closest living relative.
Only for death. That statute only relates to end of life. It does not relate to course of treatment. It only relates to end of life. If you're suffering a severe dementia and you wanted certain types of treatment given, you don't have healthcare powers of attorneys and living wills, that treatment's not going to be given. But there is a statute that specifically refers to end of life, and it gives the order of who can direct end of life procedures.
And it's pretty clear cut. So it's your spouse, it may be your oldest living child, it may be your mother or father, so that first degree relative, and then siblings, and so on and so forth. Now, this form goes in a lot more detail than the goldenrod form. Now, the goldenrod form, you fill this out one time, and if you never have an expiration, if you don't put an expiration date on it, this form goes with you wherever you go. You go to the hospital, this form goes with you. You go to the nursing home, this form goes with you. And it can be honored in any of those places. This one is called the most form, and it does something a little bit different. So if you look at the different sections that are here, first is exactly what this says. Do you want to be resuscitated? But it goes in more detail. It says, do you want to be ventilated? Or do you want resuscitation where they pump on the heart? Or neither one of them. Just make them comfortable. Second one is medical interventions. So medical interventions are things like full scope or limited scope or comfort measures only. So when it's full scope, that means, hey, we're going to do any and everything we can to keep the body alive. Limited scope says, okay, well, I want a limited trial of X, Y, or Z, but then I want to stop. And then comfort measure says, well, don't do any of those, major life-saving things. Just keep me comfortable. Give me some oxygen, give me a little morphine, give me a little rest, and turn me every now and then, and I'm good, right? The next one is around antibiotics. So people decide whether or not they want to have antibiotics. Maybe it's just by mouth only, maybe it's by IV for a limited time, and maybe it's not at all, depending on your choice. Then there's another section for IV fluids, same kind of thing. So one says, you give me IV fluids for as long as you can keep me alive. The other says, maybe for a little bit. And then the others say, don't do it at all. And then the last is around feeding. So artificial nutrition. So artificial nutrition, especially when it comes to tube feeding, in a patient who has had a stroke and maybe had an issue, or a patient going through chemotherapy for esophageal cancer or something else, when that person is still with it and has a great quality of life, those can be life-saving. When it comes to dementia, the studies are clear, 100% clear. It only prolongs life. That's it. There's never been one study that found an improvement in quality of life. It prolongs life and may increase medical complications because the tube can come out, it can get infected, there are all sorts of things. So there's a section in here on artificial nutrition to address patient wishes around that as well. Now, this has to be in discussion with your physician or your advanced practice provider, such as a PA or an NP. Nurses can fill them out, but we have to sign them. We have to basically say, yes, I agree, we've had that discussion. Now, this one can go with you as well, but every time you go from a different level of care on the back, they're supposed to go through it with you and say, is this still correct? Are these your wishes? And if they aren't, if those wishes change, a new form is filled out. So this form is what we would call a living form, right? So this form can change over time depending on the patient's condition. And so early on, it may just be, well, I don't want to be resuscitated. I don't want my heart pressed on. But everything else is okay. And then later on, things happen, things change, memory problems, quality of life goes downhill, they make a change in their decision, and so there's a change in that form that can occur for patients. So those are just a few of the medical side, and Branson and I were talking a little bit, and another thing I'm often called on to make decisions on, and it's not a medical issue, is around competency. Is that person really competent to make that decision? That is not a medical term, and that is not a medical diagnosis. That is not something I can tell anyone. That is for the court to decide. That is for a judge. Now, they come to us and say, will you write a letter concerning the patient's condition and where they are in their stage, but I don't determine competency as a medical professional. So just a little bit of what we talk about sometimes with families. And that's one of those things. It's usually, well, Mama signed a check and it went to my brother or my cousin, or her grandchild came in and said he needed a check for X, Y, or Z. She gave him a check and she shouldn't have been giving him those checks. That's usually where things happen. I think we talked a little bit last time about how, sometimes family can be the worst family when it comes to situations like this. They really can. We've seen that over and over again. So it becomes challenging. Now, the other part is really around expanding on what we talked about last time, and it's safety. For the rest of my focus, when it comes to end of life, it's about safety for the person. So if you're part of my practice and you come in and let's say Warren comes in and says, you know what, Nikki's gotten to be unbearable. She can't do anything for herself. She's not operating the microwave. She's turning the oven on and leaving it on for hours. And I walked in there one day and there was a pot melted to the stove. Okay? That goes beyond a problem that it's a medical condition. It is now a safety concern, not only for Nikki, but for Warren as well. Because now we are doing something that is unsafe, and we need a safe environment. My own grandmother tried to dry a newspaper in the oven, set the oven on fire. She cooked something in the microwave for 60 minutes. We don't know what it was. Because by the time we saw it, it was a black, round piece of charcoal. Don't know what it started out with. She couldn't remember. But she had turned that microwave on for 60 minutes thinking it was the way that she would cook it in the oven. Right? That's when the oven got unplugged, the microwave was taken out of the house, and somebody else did the cooking. And the only thing that they could do is go in and, all right, here's your meals, right? Because it became a safety problem. Driving is like that. When is the right time to stop driving? I told you last time, that is like the worst conversations I can have with families. I'll be honest, I will have the big C talk with anybody, anytime, if I never have to do another it's time to quit driving talk. You want to see somebody fight tooth and nail? That's when it'll happen. Whether it's safe or not is not part of that determination. It is just difficult. And yes, there is a medical time when that just is no longer safe. And being my advocate role that I have for my patients, I have to have those conversations and say, it is no longer safe for you to do this. So, just some of those things that come into play when we're dealing with late stage, moderate dementia. And there are other things that come into play. And then there's that inevitable time where I can't do this all myself. So what do? I can't do it all myself. I need help. One of the best things I can tell you that are my age and younger, long-term care insurance is probably a good investment. Long-term care is expensive. It is not covered under Medicare. And you want to see somebody's retirement savings go up in smoke? Long-term care is where it's at. We are talking between $5,000 and $9,000 a month for long-term care services between an assisted living facility with a memory care unit or a nursing facility with a memory care unit. It's expensive. That's why you hear stories of this lady that decided she was getting older, she needed her walker. She really couldn't do her own housework anymore. She was tired of doing lawn work. She was tired of hiring somebody to do it and was trying to decide whether or not she was going to go in a nursing home or an assisted living facility. You know what she did for 4 years? She lived on a cruise ship.
It was cheaper?
It is a true story, and it is cheaper to live on a cruise ship for 4 years than it was for her to go to an assisted living facility. So,
People say this, I heard that places like motels and stuff like that.
Yep.
Because you can get a motel room cheaper.
and it was cheaper for her to live. Her bed got made. Her meals were made for her. If she needed anything, the stewards were right there. There was free medical facilities on board, right? She could get her medications. She had everything she needed and got to see a lot of the world in the meantime. 4 years she was on a cruise ship. So it's not just a myth out there on Facebook. This woman, we actually had the pleasure of being on a cruise ship where there was another gentleman doing the exact same thing, and the stewards knew him by name. Mr. So-and-so, oh, he got off to go to the drugstore. He'll be back in a little bit. He'll be on our next cruise. But it's expensive. Long-term care insurance doesn't cover it all. but it may cover for some things like in-home care services, some assisted living facilities, some skilled nursing facility coverage that goes well beyond what Medicare is going to pay for. Yes,
Well,
ma'am.
I know this lady that had that long time care, and when she started using it, she had to start filling out taxes again because it was taxable
Yeah.
income.
Depends on if you paid for it pre-tax or post-tax with the premiums paid. So she actually made a bad choice and paid for it as like an employment benefit. So she paid for it pre-tax, that meant the benefit was taxable when she received it. So her mistake, her accountant's mistake. But most people don't have to, because they use post-tax dollars to buy or pay for the premium amount. When you do that, the benefit's not taxable. Same as life insurance. If you buy a life insurance policy pre-tax, the benefit to your heirs is taxable. If you buy that life insurance after you pay the tax on the money, then of course that benefit's tax-free.
And unless you guys have questions for me, this is where I'm going to turn it over.
And all I'm gonna do is chat about what happens and what you probably ought to have in your holster of goodies to keep yourself safe is really what it boils down to. And as he clearly said, there are medical directives that he can fill out that try to help the situation. The problem is when the EMS shows up at your house and they've been alerted you've had a heart attack, they're not going to be looking for a yellow form on the refrigerator. They're going to be over there trying to resuscitate you. And normally what happens is you end up at the hospital and your healthcare power of attorney shows up and waves that paper and says, is she out of it? Because if she is, I get to make the decisions now. What happens in my world is I run backup to his world. If the medical system fails, you've got to have a legal recourse, is what it boils down to. And most people don't realize, but there's actually 3 documents you need, and you don't need to wait till you're 85 to come get them. You probably should already have them. 2, he mentioned, and I mentioned them as one document, healthcare directives. And when we start talking about healthcare directives, that actually is 2 forms working together. The living will is just simply a declaration you'd like to die a natural death. And then there's a healthcare power of attorney. You're appointing somebody to carry that out. So that living will just says what you want. And then the healthcare power of attorney says, I'm going to appoint somebody to carry out my wishes. Most people don't get it, but your healthcare agent is actually who disposes of your body now. So when you go to the funeral home to prepay your funeral, they're always asking for the healthcare power of attorney. Who's got the right to dispose of the body? Because that's got all the autopsy language in it, if whether or not you want an autopsy performed or any of that stuff. So my comment to you guys is you don't have to have 2 separate documents. There's still lawyers that put the healthcare directive, the declaration for a natural death. You just put it inside the healthcare power of attorney. You don't have to have 2 separate documents. So long as your declaration is declared, it can be in one document. So, but for years, the healthcare power of attorney and the living will fought. What happened was, there was a little girl named Terry Shivo. Y'all might have heard her name before. She went to U.S. Supreme Court a couple times. She was a little old gal, took a bunch of diet pills and came home, and the husband found her where she wasn't responsive, and they sent her to the hospital, and she had a living will, and it was her declaration she'd like to die a natural death. She gets to the hospital, and the husband comes in there with his living will, waves and says, don't plug her up on anything. She's already plugged up, because remember, nobody found that yellow form, so she's already plugged up, and he shows up with that living will, don't plug her up. Well, then the parents show up about 30 minutes later and said, oh no, she recognizes us. Don't take her off. Well, she had a directive that said if I'm in a persistent vegetative state, please do not give me artificial nutrition and hydration. But the problem was the doctor said, throw my hands up. Either way I go, I'm going to get sued. I don't want to be sued. Y'all go to court and the judge tell me what to do. They were in court 15 years. It went to U.S. Supreme Court twice. Even had presidential intervention once or twice. But the bottom line is, she died of natural causes 15 years later. Most of her brain had atrophied, except for the part where she was feeling pain. So there's a special place in hell for parents like that. That's all I've got to say. But anyway, neither here nor there. Let me go. Don't let me lay. So my comment over all of this is, the states flipped out. They said the little will's not enough. So they went ahead and developed health care powers of attorney. And it says, we're going to appoint somebody to be able to handle this stuff for myself if I can't do it for myself. So I've got a health care power of attorney. Now, what happened was, if you actually looked at a living will, it says, I direct my physician to withhold artificial nutrition and hydration. You give an authority to physicians. The healthcare agent says, I direct whoever you appoint to carry out your wishes. Under the old law, like I said, the two documents fought. And now the newer set of documents they've come out with kind of dovetail each other a little better than the old ones did. Because you might have a doctor saying one thing, you might have the healthcare agent saying something else. But Mama said, don't plug her up. Doctor says, well, there's a chance of recovery. We're going to plug her up. And believe it or not, the case law leaned to what the doctor said for a long period of time. Now it's kind of shifted with the new forms. But I don't really like writing separate living wills. I like putting a declaration in the healthcare power of attorney. And it just simply says, I desire my life not be prolonged. If I am terminally ill, permanently in a coma, suffering severe dementia in a persistent vegetative state. If you hit one of those four and you're not going to get better, I don't see a whole lot of reason to plug you up. But you can put all that in one form instead of having the two competing forms. But anyway, that's my preference. There are other lawyers that do it differently. The pre-printed forms you can get are two separate documents. Just make sure they work together, dovetail. Check the right box, that's what I'm trying to tell you. Now, I always have people call me all the time. Mama's sick, she's in the hospital, we need to pay her bills. And it's just like, if you got a car and it breaks and you go to the mechanic's house, he's got tools to work on that car. You need to make sure your family members have tools to work on your stuff. If you break, you can't do for yourself. And what I mean by that health care power of attorney is a big deal. It is a big deal, because that way your family has the tools to be able to assist you. But we haven't talked about finances, and he mentioned a little bit of it, but finances, they're brutal. And the reality is you need to get a financial power of attorney, and it needs to be a durable power of attorney that survives incapacity. And what that means in a nutshell, somebody can sign your bills for you. It needs to be more than just your bills. It needs to be your car titles, your land, and everything else. Because if you go to long-term care, the nursing home's waiting to get it all. Well, you try to protect those things. That's what you do to keep the nursing home from taking it. So my comment is, there's a set of tools that you give a family member to help you if you can't help yourself, called the health care power of attorney and the power of attorney. Those are pre-death items. That's what you do pre-death. Post-death, need a will. It's who gets your stuff and instruct somebody to pay your bills. When I write a will, there's basically 4 sections to it. The first section is just administrative. Pay my bills, give me a proper burial, give me just funeral, make sure everything's situated, and if I owe an inheritance tax, state that out. What nobody realizes now, the inheritance tax limit is $12,920,000, so nobody I know is going to pay it. So everybody flips out and they say, oh, we want to avoid inheritance tax. I said, I bet you will. And anyway, I just usually leave it at that. Because nobody owes it anymore. It's so dang high. Married couple can come in my office $26 million and not owe a dime. But when we start talking about inheritance tax, there used to be a state and a federal. Now the state's been abolished in '09. The federal's still out there, and it's up to $12 billion. So in essence, when we write the will, first thing we do is pay the bills. The second part of your will would be specific bequests. If you have certain items you want to go to certain people. I want to give my mama's china to my daughter, and I don't care if my son gets a piece of it. You can actually say what you want to go to specific people, and those are specific bequests. But when you get done giving out those specific items, you write a residuary clause. When we write the residuary, it just says, I give the rest, residue, and remainder of my estate to my wife, if she shall survive me. If my wife shall predecease me or fail to survive my death by 30 days, I give, devise, bequeath the remaining assets to my 3 children in equal shares. Should any of them predecease me or fail to survive my death, their share shall go to their issue. Issue meaning heirs of the body. Should any of my heirs be below age 25 years at the time of my death, their share they shall receive shall be held in trust by trustees, so they won't piss it away. So we'll have it, and it'll be cared for, and they can dole it out to them and make sure they get through college or taken care of. Okay? So what have we learned? We're going to do the administrative part, specific bequest, now residuary bequest. And if you want to put a little in for the preacher or the church, you can. I give 10% to the church, and the remainder goes to my 3 children in equal share. That was supposed to be funny. Nobody laughed. Anyway, I get it. Okay. And then last but not least, we have to appoint people to carry out the work. The first thing we appoint is an executor. That's the person that's going to pay your bills, gather your assets, and disperse what's left to your heirs. Secondly, if you've got minors that need trust, you've got to appoint somebody to be able to minors' money. Sometimes you might want it to be the parents. Sometimes you might think the parents are idiots, and you might want it to be somebody else. You get to pick that. That's your choice. So in essence, there are 3 papers everybody should have. A power of attorney. Who's going to help you with your bills if you get sick? And to be honest, the 2 powers of attorney to me are a lot more important than the last will and testament. I don't care what they do with my crap when I'm dead. I'm more worried about me while I'm alive. Take care of me now. Yes, ma'am.
What's the difference in the power of attorney and the executive?
Easy. A power of attorney can help you while you're alive. Your will doesn't take effect till you die. After death, alive and dead. That's what we're talking about. So the 2 papers to help you while you're alive, healthcare directives. Some people use a separate living will and a healthcare power of attorney. Then your power of attorney to help you financially. But at death, it's that last will and testament. And you ma'am.
2 power of attorneys like a medical or power of
Separate documents, separate statutes in North Carolina. North Carolina General Statute 32A is the healthcare power of attorney statute. North Carolina General Statute 32C is the power of attorney statute. Power of attorneys are odd beasts. Up until 2018, when you wrote a power of attorney, it was state specific. Believe it or not, every state has their own power of attorney statute. So if I wrote a North Carolina power of attorney and had property in Tennessee, I doubt they're going to let me sell it. So the states have gotten together and they formed the Uniform Statutes Commissions. And what they're trying to do is provide some uniformity from state to state over basic documents. Well, North Carolina adopted the Uniform Power of Attorney Act January the 1st of 2018. So if you've got a pre-2018 power of attorney, I would hope you'd probably call your lawyer and say, let's update to the new statute. The reason being, the new statute thinks of lots of things the old one didn't. One of them, for example, being able to handle or direct or close your electronic communications accounts. That's in the new statute. So if you got email scammers and you're crazy and you're giving them money, your power of attorney can close that account to keep the scammers from getting to you. So I'm a big fan of the 2018 forward statute, even the basic document that they give you, the pre-printed form. I'd much rather see you have that than nothing. But mine goes well beyond that, and I'm going to tell you why. There's a case in North Carolina, 1987 case in North Carolina called Whitford versus Gaskell. And what happened was a farmer down in eastern North Carolina, he had a pretty good sized estate, and he gave one of his girls power of attorney. Come to find out, that girl was a turd. Because when Daddy got sick, she said, I'm going to protect Daddy's stuff, put it all in her name. A couple years later, the will was read. And when the will was read, it said, I want both my girls to get it. The second girl goes to the first girl, and the first girl just kind of throws up her hands and says, sorry, you out of luck. Power attorney's power attorney. Second girl's pissed. She heads to the county courthouse, files a lawsuit, and the judge says, power attorney, you out of luck. Appealed it to the North Carolina Court of Appeals. Court of Appeals said, power attorney, you out of luck. Appealed it to the North Carolina Supreme Court. North Carolina Supreme Court said, you can't make a gift deed with a power of attorney unless you've got specific gift-giving powers for real estate. Well, my elder adults that are going into long-term care or later in life need that gift-giving power because there are ways to protect real estate from the nursing home spin down if you add somebody to the deed. But if you don't have a gift-giving power, would we be able to add somebody to the deed? We got problems there. So, what I write, I try to go beyond to actually anticipate problems that could come up that are beyond the basic statutory short form, is what I'm trying to tell you. But I'm not going to complain if you go get a short form, the statutory document. That's better than nothing. So go get your documents, those three. The living will, healthcare power of attorney, and the power of attorney. Get those in hand. That way people can help you while you're alive. But that last will and testament, let me go ahead and say this. If you don't write a will in North Carolina, state law writes you a will. It's called intestate succession. And what happens is, if you've got a spouse, no children, it goes to your spouse. If you've got no spouse but children, it goes to your children. If you've got a spouse and children, it's a split between your spouse and children. So everything doesn't go to your wife or your husband. It's a division. Now, if you've got no spouse, no children, it goes back to parents. Well, if they're in the Lutheran home and you die, it goes back to the parents. Who gets your money? The Lutheran home. So you want to try to anticipate these problems is what you want to do, and try to avoid seeing your money go where you didn't want it to go. And you can designate that in the last will and testament. Because if you don't do it, state law's going to write your will for you, and that's what's going to happen. If you don't have spouse, children, parents, then it goes to brothers and sisters, is really where it goes. No brothers and sisters and nieces and nephews. I think it goes 7 degrees before it begins to eschew to the state. But in essence, it's just, if you don't have to write a will, state law writes you a will. A lot of people come in and they say, well, I want to do a trust. They don't know what a trust is. I'll explain what a trust is. A trust is a contract between three people. There's a grantor. That's the person giving their assets. There's a trustee. That's the person that holds the assets. And then there's a beneficiary. That's the person who gets to use some benefit of the asset. So if I did a trust, I could let Dr. Connelly hold my stuff for my use and benefit during my life to my children at death. Well, if I do that, there's no probate because the trust doesn't die. Because if I appoint him first trustee and he can't do it, I'll appoint a second trustee, the successor trustee. So that contract doesn't die, which means there's no probate on those assets. People say, oh, is that the way to go? And I'm not a big fan of it. It was a viable tool, more so when the inheritance tax limits were low. We could use that to bypass some inheritance tax consequences. Now with it being $12 million, it's just easier for you to take your 401k or your IRA and put a beneficiary on it. It's easier for you to take your checking and banking accounts and put POD on that. And that's allowed by North Carolina law That is a signature device where you appoint beneficiaries on your accounts. POD. All you gotta do, and it doesn't go through probate. If I die, I went to the bank, I signed who I want to get it at death. So when I die, they show up with my death certificate, they get a check. It's just that simple, no probate. Let's say I got 1,000 shares of Apple stock. And I don't, Apple, the computer, not the food. But if I got Apple stock and I don't want it to go through the probate, I can put a TOD on that account. Transfer on death. It's just designated beneficiary once again. If I die, the stockbroker got a TOD on there, it's going to go to the next beneficiary. It's just like life insurance, except there's special names for these types of beneficiaries. But you can do that, and it doesn't go through probate at all. So the cost of creating this living trust that people come in and want to do, it's just really not worth it more often than not, because you're not going to exceed the $12 million inheritance tax bracket. The next big question he brought up is nursing homes. And I hear people ask me questions about, Mama's sick, what are we going to do? All the time. And to be blunt, there are 5 ways to pay for care. The first way being your health insurance. If you fall and break your hip and the doctor plates you up, he's going to send you for rehab. If you spend 3 nights in the hospital, your Medicare will pay for the first 20 days. Now, at day 21, that changes. Medicare will continue to pay, but there's huge daily deductibles. Unless you have the Mac Daddy Part F supplement, it's not going to get covered. So you're going to be paying out of pocket $197 a day now from day 21 up to day 100. Now, at day 101, Medicare quits, and Medicare quits, the supplement quits, so you're on your own. There are 4 more ways to pay for care. The first way sucks, private pay. I don't care what you got, they're going to run through it, they're going to get it hard. And I'm seeing bills closer to $11,000 instead of the $9,000. And I see them regularly. The second way to pay for care after the 100 days is up is long-term care insurance. I love it. I think it's the way to go. Problem is 2 problems. Number 1, you have to medically qualify. I've got a mild cancer called essential thrombocytosis, and they laugh me out of the building whenever I say I want it. You can't have it. We'll charge you 4 prices for it. Well, good. Okay, I just won't have it. And so medically, I can't qualify. But then the second thing is cost. It is expensive. And all you are buying in a long-term care policy is a pool of money. You can buy an expensive long-term care policy with a big pool of money, or you can buy a cheap long-term care policy with a little pool of money. You have to decide how much supplemental income you want or need and what you're willing to pay for. Now, what I have seen recently is there are annuity devices you can purchase that convert to long-term care policies. And I think if I was looking to do that, they're easier to qualify for, and your heirs get some benefit from that if it doesn't get used. So I think that's a much better way to go than just buying straight old-timey long-term care insurance. The third way to pay for care after the 100 days, any of y'all serve military service? Not a one. Okay. There is a VA aid and attendance program. They'll pay $2,100 a month towards your care. If you go to the VA Building 10, that's a state-run veterans home, believe it or not, it's federally subsidized. It's only $3,400 a month. And they're going to give you $2,100 a month. It's a bargain. It only costs you $1,400 a month. But since no veterans are here, we're not going to talk about that. And then last but not least, we deal with an umbrella of programs we refer to as Medicaid programs. Now, Medicaid is very different than Medicare. Medicare you get due to an age or a disability. Medicaid you get based on income and assets. You got to be poor. Used to be years ago when somebody showed up in my office and they'd say, Branson, my mama's sick, can we get her Medicaid? I'd say, sure, let's make her look poor. We'd take stuff out of her name, put it in the children's name, get in the car, flames in our hair, and ride down to social service and sign them up. And believe it or not, it worked. But in 1993, the government figured out I was putting everything in the children's name, and they got mad. The government passed 2 rules to keep you from turning everything over to your children. Let's talk about it. The first rule is called the uncompensated transfer sanction. And everybody says, what the heck does that mean? It's simple. An uncompensated transfer, that's a transfer mama makes where she gets nothing in return. It's a gift. And then sanction means penalty. It's a gift penalty. What it currently says is for every $7,810 you give away, there's a 1-month period of ineligibility. And everybody says, what the heck's that mean? Well, if I take my $78,000 CD and put it in my daughter's name and they catch me, they're going to take that $78,000 gift divided by the $7,800 per month penalty. There's a 10-month penalty period. What's that mean? I got to pay for the first 10 months. Well, that sucks because it costs $11,000 a month. I'm going in the hole. Well, how do you undo the penalty? It's simple. Undo the gift. So they got me. They got me. The second rule they passed is one everybody knows about, 5-year look back. And all that means, we show up at the Medicaid department down at Social Services, sign mama up. Well, we're going to look back over her stuff for 5 years. What are we looking for? 2 things. Number 1, what you got? Why they want to make you spend it. Number 2, what you gave away. Why they don't penalize it, force the return of it, and then make you spend it. They got you. All right, so Medicaid is a program that'll help you, but it kind of forces you into poverty to help you. Now, let's talk about that a little bit. Let's extrapolate on that. What happened was in 1990, the government is not heartless. So let's go on. In 1993, when all that mess passed, middle-class America had a heart attack. Why middle class? It's all they affected. Doesn't affect rich people. You got a $20,000 a month income and your wife gets sick, it doesn't really matter. You pay for her care, you still got plenty to blow every month. So rich people didn't get hurt. Vice versa, it didn't hurt poor people. They just drive down there and sign up. But people in the middle, they get crushed. They got too much stuff to qualify, but not enough income to pay for care. And everybody says, what's that mean? Well, you can't keep your stuff and qualify. We learned, can't keep your stuff and qualify. You got too much stuff. Can't turn it over to children and qualify. Why? Triggers penalties. So you're forced into spending down your money and assets. Well, what happened was the government said, we're not going to take everything. We're not going to take everything. So what they actually do now is they take an elder adult's assets and they classify them as countable and non-countable. If you have a countable asset, it counts against you when you're applying for benefits. The best example I can give you of a countable asset is a liquid asset. That's bank accounts, stocks, bonds, insurance and cash value. All that. So anything that be readily convertible into cash is cash. It's a liquid asset. You can have $2,000. If you got $2,001, you got one countable dollar and it won't help you till you spend that dollar. Then the converse of that, they're non-countable assets. For example, let's say I got husband and wife, Mickey and Warren. Warren gets sick, he ends up in the home. Well, Mick still needs a place to live, doesn't she? So the rule said, if you've got husband and wife and one spouse still continues to live in the house remains non-countable. It doesn't count against his Medicaid application. So in essence, that is an exempt asset. What I help people do is if they end up going into care, I don't want to give you stuff to the kids, it triggers a penalty. And I don't want to hide the stuff illegally because I'll send you to jail. So what I help people do is turn their countable stuff into non-countable stuff so you don't have to spend it, you can keep it. Now, the problem with that is there's 4 government agencies that watch, and we're going to call them the 4 devils, for lack no better place than that than here in the church. 4 devils, and we're going to learn to touch on each one of the 4 real quick. Number 1, social service. What do? Transfer sanction look back period. We've already learned what they do. They're looking for gifts. Number 2, Medicaid estate recovery. Medicaid dollars are federal dollars. They're given to the states pursuant to block grants, and for the state to get that money, they got to comply with federal guidelines. Well, the federal guidelines say you have to have a plan in place to try to recoup monies out of people's estates when they die. So if you die and will your house to your children, the children aren't going to get it because the state's going to place a creditor's claim against that will. They're going to sell your house, take the money, and they'll give the crumbs that's left to your children. So we don't want stuff to go through the will. We want to bypass the will. How would we do that? Very simple. If I have a deed with Warren and it's a right of survivorship deed, if I die, it goes to him, he died, it goes to me. So in essence, we don't have to worry about that sucker going through. They're too late when they show up if we've got a right of survivorship. Okay, so there are ways to avoid that. Third thing I worry about is gift tax. If we start giving stuff away, it can cause a gift tax. Two kinds of gift tax, state and federal. We learned the state gift tax was abolished in 2009. We don't have a gift tax or an inheritance tax. Federal gift tax is alive and well. 3 ways to avoid it. Number 1, gifts between spouses. So I can give to my wife, she can give to me, and they don't care. Number 2, we have the $17,000 annual exclusion. You can give anybody you want $17,000. You don't even have to fill out a gift tax return. And the problem is, the accountants will tell you, you can give away $17,000. You can under the tax rules, but you can't under the Medicaid rules. They're 2 different systems. They don't work together. So I have to undo what the accountants tell you to do sometimes because they forget there's still a Medicaid penalty out there. And last but not least, we have something called unified credit. Now, I said a while ago, you can die with $12,920,000 in your state not paying inheritance tax. Well, the government's nice. They say, why make people wait till they die to give their $12 million away? So if I want to give this boy $1 million today, I can. I just take that million, write him a check. But I got to fill out a return and take credit against my inheritance tax exemption. So when I die, I've only got $11 million worth of exemption still left. I can do it now or later, but I can't do both. So they let you do each one you want. And then last but not least are IRS problems. I have people come in with IRAs. IRAs are countable cash that make you spend it. There's only one way to spend your IRA, and that's take your money out of IRA. Well, if you got 100,000 IRA, you really don't have but 80 to work with because you got to take it out. And they're going to withhold the tax, and then we take what's left and move it to the non-countable side of the equation. Now, the thing of it is, people say, I want to leave that IRA for my children. You're not doing them any favors because if they inherit it and they take it out, and they take it out at their working rate. Their rate, and they're currently working, so they're going to get hurt. So IRAs, you got to spend something, you get sick, that's the best thing to spend right there. Then last but not least, what about capital gains? Everybody heard that word? Capital gains is tax on a long-term investment, such as a piece of property. Let's say I bought a deed for $5,000. What I paid for that deed is called cost basis. Let's say I can sell my 5,000 deed for $15,000. I'm going to make $10,000. I'm happy. So's the government. Because they're going to charge me capital gains tax on that $10,000. 15% federal, 7% state, 22%, $2,200 in tax. Now, let's say this boy here's my best friend. I'm going to give him my deed. Here's the rule. If I give him the deed, I give him the cost basis. If I got 5 in it, turn it over to him, he's got 5 in it. It's called a carryover basis. So in essence, if I was going to make 10, he's going to make 10. He's going to owe the same tax I was going to pay. Now, there's a second rule called a step-up basis. If I give him that deed at my death, doesn't matter if it goes through a will, trust, even a life estate deed, or a right of survivorship deed. He takes it at death, he gets to reset that value to the death value. So if he takes it at death, he takes it at $15,000, sells it for $15,000, zero profit, zero tax. Best time to give your children a deed is at death, so they can benefit from that step-up basis. So my comment overall is when you end up in long-term care, they're going to make you spend your stuff unless you can figure out a way to move it non-countable. Your problem is to move it non-countable. If you're sick and you're in a care facility, you can't help me do that. You better have power of attorney able to come up there and help us do some stuff for you is what I'm trying to say. This is a very important tool. Wow, that was a long conversation to get to the point of you needing a power of attorney, but anyway, that's kind of where it is what it is. So my comment over all this, what have we talked about today? We talked about living wills, not a fan of them, but they're out there. We talked about healthcare power of attorneys, those two work together. We talked about powers of attorney, somebody being able to handle financial matters for you. Then we talked about your last will and testament. Then we've also talked about Medicaid and how they could help you offset the cost of care by moving stuff from countable to non-countable. But in that process, there's 4 government devils we've got to watch out for. So we talked about a bunch of crap. Questions, comments? I know I was rambling on there, and I figure somebody got a question. I'm happy to talk.
I'm depressed.
I will guarantee you, if you showed up, I'd fix it. There's lots of ways to move stuff non-countable.
You say you recorded that?
We are. And what I would say to all of this, and the point of this whole series really has been around, how do you plan for this, right? And as you can tell, it's not once the diagnosis is made. Planning starts well ahead of that. My wife and I put our stuff down in 2002. Our youngest was 2 years old. That's when we started planning. That's when we went ahead and made some decisions. And we did just what Branson said. Don't give this to that one, because he'll spend it. This one gets it. Or is the trustee. You got some decisions to make. And it's really important that you do that early on and have those conversations. Even though those are not comfortable conversations, we're not really good at talking about death. But death is a part of life. And we've got to plan for it. We've got to plan for any number of things. And we see it all the time in both of our professions, from 2 different lenses. But a lot of times, we see it way too late. Way too late. You have a question?
Yeah, I wanted to ask him, he said, if your spouse goes in a nursing home, talking about the Medicaid.
I got it with you.
And the other spouse still living.
That's correct. The house is
It's
non-countable.
non-accountable. But what if one spouse has passed away and the other spouse goes in a nursing home?
Well, they ain't a spouse living in the home anymore, is there?
Right.
You answered your question. It's
So
countable.
It becomes accountable.
Yeah. So what you do at that point is there's a rule called non-countable ownership interest in the Medicaid rule manual, and it clearly says life estate deeds are non-countable. So if you did a deed from yourself to yourself for your life, that deed would become non-countable for the remainder of your existence. Now, is there a penalty for you giving yourself a life estate? No, you didn't give anything away, did you? You're keeping the lifetime right. Now, the rule goes one step further. What we're doing is dividing the deed into alive and dead. While you're alive, you're keeping it. Life estates are non-countable. The deed at your death remains, and that's called a remainder, legally. And there's a rule in the book that says remainder interest becomes non-countable if there's more than one remainder holder. Well, I'm assuming you have a child, and I hope you like them, because we can add your child to the remainder interest, and we would have more than one remainder holder, wouldn't we? Now, I want you to think about this with me just real quick. Would I want to give that youngin' a big piece of deed for a big penalty or a little piece of deed for a little penalty? Little. Smaller the better, 1%. Tiny little piece. So if you got a $300,000 spread, and I give them 1%, that's $3,000. Would you lose $3,000 to keep a $300,000 house? If your youngin' don't want to, let me know, because I'll give you the money, but I need to put my name on the deed. Now, let's keep going. What just happened is we took the deed while you're alive and made it non-countable. We took the deed while you're dead and made it non-countable. Is there any other time periods? No. Alive and dead, there's no other time periods on the deed. That's the whole deed, isn't it? Now, what just happened? The first devil. The first devil was the Medicaid penalty. And we just learned it's only 1%. We're going to pay it. Show it to them and pay it. Who cares? I'm getting a $300,000 house for $3,000. I'm all for that. Number two, Medicaid estate recovery. When he dies, his lifetime right disappears, doesn't it? Because his lifetime right disappears, when them fools from Raleigh show up, they're too late, aren't they? Secondly, the 99%, 1%, if we do that deed and create a right of survivorship in that deed, if he dies, his 99% immediately goes to the children. So, when Raleigh shows up, they're too late because the deed's already in the children's name. Because his life estate evaporated, the 99% went directly to the kids. So we beat the first devil and the second devil. The third devil, gift tax. We didn't give away but $3,000, did we? And we can give away $17,000 per year. So what? We just beat the third one, the fourth one. Because he kept a lifetime right in that deed, that youngin gets that deed at death. And we learned there's a step-up basis at death, didn't we? Well, we just smoked the Department of Social Services, didn't we? By adding a child a partial interest in that deed. But if he had a stroke, couldn't sign his name, and he didn't have a power of attorney, how in the heck are we going to do that? Thanks for bringing that up. So, like I said, if you're sad, you bring it up there, we'll fix it.
How far in advance do you have to do all that?
The 1% deed, you can do it 15 minutes before you go into the home. And the reason I say that, we're going to disclose the 1% gift. We're going to pay the penalty on the 1% gift. We don't care if they catch the 1% gift. So that can be done today and be sick tomorrow. So, and there's lots of other things. Let's say he's got $300,000 in the bank and can't have but two. Well, I'm going to spend $298,000 on another deed. And then I'm going to give 1% of that deed to the kid too. That way they both get a place. Because in the rule book it says you can't gift your money away, but you can spend your money on any object, service, or benefit. So if you came into the Department of Social Services, the first thing the social worker is going to tell you is, have you paid your burial yet? They're telling you to go take $10,000 and pay the funeral home and make sure your burial's paid. Because burials are non-countable. That funeral bill is non-countable. Well, I'm doing it on a big scale. Just bigger than they do. Not breaking the rule, I'm going to show you the rule. And actually, I brought my computer to show you the rule, but I'm not going to print that stuff now. But in essence, it's there. The rules are clear. You can spend the money. So if your choice was to spend the money on the Lutheran home or to spend the money on something non-countable your mama could keep, what would you want to do? I like mama. So we'll spend it on mama, non-countables. And the rule book says we can do that. But we want to do it without pissing off the 4 government devils. Everybody got quiet.
I like to say, when Mickey and I got married, the second marriage is separate kids, separate assets, and someone recommended this fellow, and we went over to sit in his office probably an hour and a half or more. And he ran through all this stuff. Well, Branson, we kind of thought we did. No, you don't want to do that. And here's why. And when they were talking about this workshop, we couldn't think of anyone that would do a better job than Branson Pethel. So go to see him if you got issues, you got questions.
Well, I appreciate your vote of confidence.
Hey, he'll fix it for you. And you don't charge an arm and leg either.
Depends on how much you got.
I can't receive.
Yeah. But it's fun. I mean, I talk about practicing law, and they call it practicing law for a reason, because you screw up on the first beat when you try to get it right on the second beat. But as I've aged, what I enjoy doing is seeing what I can get away against the Department of Social Services, Health and Human Services. It's kind of a cat and mouse game. I try to push the limits of what I can get away with, and they push back, and then I'll just go down another path and push them again, and they push back, and you know, I about got them people in Raleigh trained now, though. We're doing pretty good. Yeah, we're doing pretty good. But yeah.
This bothered me when my husband passed away.
Yes, ma'am.
They told me to go down to the clerk of court and I guess take a death certificate or whatever. And they handed me all these papers I needed to fill out. Well, I didn't really need to fill out those papers because everything was in, my name was on everything but one document. And we got monies from that document. I had to take it back to the clerk of court to pay them $3 to get to cash that check.
That's correct.
Explain that to me.
What happens is, when you die, your assets are either a probate asset or a non-probate asset. The term probate is a Latin derivative to prove. To prove. And what you're trying to prove is the bills are paid. So when you die, the clerk of court makes you, the state law, you prove that everything's settled. Assets, when somebody dies, are either going to go through probate or not go through probate. And I gave you lots of examples of how to avoid probate. A beneficiary clause on an insurance policy, a TOD on a stock account, POD on a bank account. Probate is a minimum of 3 accountings. The first accounting is where you submit the assets and you apply to become the executor. That's the person responsible to notify the creditors, pay the bills, and give what's left to the heirs. The second's a 90-day inventory, and that's when you have to disclose to the clerk what you have. And then lastly is a final account where it shows all the bills are paid and all the money's given out. Now, my assumption is it was less than $60,000 because the process you described is not probate, it's a collection. And the process you described is a mini probate where you don't have to go through all the steps. It's available where, and actually there's a widow's allowance too. You get the first $60,000 of personal property.
It's like $50.
Anyway, it will probably the widow's allowance is what they had you do. But the widow can claim the first $60,000 of assets without running an ad in the paper or anything. But they made her fill the paper out so they could cash. She had a legal authority to cash the check. She had to apply to become his representative to actually get legal authority to endorse the check to put it in the account. And the clerk, of course, is going to charge for that. But yeah, that's a bargain.
Yeah.
That's a you won. That you didn't get hurt there. Yeah, but that's the widow's allowance. That's what that is. I'm pretty sure. Either the widow's allowance or a collection. You didn't do a full probate, not for $3.
Well, I hear people talking about closing the estate. Do you have to do anything for that?
That's that final account we're talking about.
Oh,
Prove your bills are paid and disperse some remaining assets in accordance with the will. And what you need to be doing since your husband's passed is you need to be doing PODs, TODs,
I've already done it.
yeah, all that crap. And then the other thing you might want to do is get your children added to your deed, the life estate remainder, to avoid the probate on the real estate. But there's things you can do down that path as well. Okay. Yes, ma'am.
If you have a will and power of attorney, how often should you revisit that?
When your life circumstances change. I will say, since 2018, if you've got a pre-2018 power of attorney, I don't like the old ones compared to the new one. So anybody that's got I even rewrote my own after 2018. It's just very personal, but if you had an heir died, or if the executor needed to change, or if you've got a 20-year-old or 20-year trust for a child, but yet your trustee is 70, they're not going to make it to 90, so you need to reestablish the trust. So you look at your life circumstances, and if they change, you need to change with it. There's no set time. And most people don't realize the power of attorney statute changed in 2018 either. And I have people bring me pre-2018 power attorneys all the time, and I don't like working with them. If I went to Walmart and bought the cheapest set of tools, and And I took them tools to the mechanic's house, and I said, I want you to work on my car with these cheap tools. He's gonna laugh at me. He's gonna say, I want to use the good tools. And when people bring me these little things off the internet, that's kind of what I do. I laugh at them and say, I don't want to work with the cheap tools. Let's get some good tools. And if somebody can still sign, we use try to get that out. But if they can't sign, I'm working with the cheap tools and skinning my notes like the mechanic. Anyway.
But Branson, power of attorney for health care, it's really no good anyway until a person gets to the point where they can't do it.
Lack sufficient understanding or capacity to make or communicate their own decisions relating to their health care. As long as they can communicate, the physician is the one that determines that. As long as they can communicate, they're allowed to communicate.
Because a lot of people, I know, kind of going through that with my aunt right now. You know, when we was redoing hers since my mom passed, and was trying to give, you know, delegate that stuff, I couldn't get her to quite understand, you know, you don't have to really do anything until she gets to where she can't do
She can't do
herself.
for herself. Now, the one thing is accessing medical records. That is wonderful to have. And that kicks in now. So, I recently lost my dad, so for a long time I was involved in his health care. He and I both had the same cancer issues, so we went to the oncologist together. And we did for years until he passed. And those medical records, I would just take them and file them away. I had all that stuff. So, and there was no qualms about it because they had the health care power of attorney. They didn't give him the papers, they gave them to me. I kept up with his papers. But anyway, yeah, the reason for the healthcare agencies, more than just to carry out the wishes of that individual, it also gives them the right to advocate for services and keep the records and those things as well. So parts of it take effect now.
And I would just echo one thing. There are a couple of different terms you may hear on our side. You may hear healthcare power of attorney, you may hear healthcare champion, you may hear proxy. They all have a little bit of different meaning as to what you have access to. But proxy really has become, it's an advent of the electronic health record system. Being able to access their electronic information is based on proxy, and that's signed by the person. Healthcare power of attorney allows us to grant proxy if the patient can't make that decision for themselves. So there's a couple of different ways that you may see those terms show up in the medical space dealing with any medical condition.
But Jason, now you talk about the DNR, and you know, and even if that's in their will, if they state they don't want to be resuscitated, just as an example of bringing mom home from the hospital, we asked for one, and they told us no. Why? Because when we had to call 911, that's the first thing he asked me for. And I told that guy, they did not give us one. And he said, that is their job.
I can't answer why they would say that.
It could be an emergency room policy. It could be
Could be
internal
it.
in the hospital. They might want you to go see the family physician to go through the actual questions. So he can't answer that.
But and if they talk to a nurse, if they talk to a social worker, you know, all of those different things kind of come into play. But I will tell you that most times, providers who work in the hospital are not doing these. Okay? The one exception would be this while you're there. So if they're trying to determine how far do you want to go, and you give them an indication that it's only so far, they may end up working with a nurse specialist who's been trained to go through this. But this right here, no, that's our job in primary care. That's who's going to do it. It's going to be your primary care specialist, it's going to be your cancer specialist, it's going to be the neurologist, it's going to be the cardiologist, depending on what the healthcare problem is. But you're going to do this through the office. They probably look at you and go, what is that for? Half of them, because they've probably never seen it. Even though we do education on what it is and why you should have it, But the unfortunate part is from the EMS standard, they have to see it. They have to see it. That is because they get in trouble.
You're in a car wreck, it's in the pocket, they're not gonna look for it.
No.
They're gonna bump on it.
And there's something called Good Samaritan. They can't get in trouble for doing it.
Why do you have it posted?
There's a chance they might see it on the refrigerator if you're
Yeah.
right behind.
And that's why I tell people, if you really want to see, put it on the door, they're going to come in through. Honestly, put it there. Because they're going to see it as they come through the door. And especially if they have to break it down. I had a patient, unfortunately, pass away in the home. Living by herself. They had to break in. It's the only way anybody could get in. They had to bust the door down.
I found with palliative care and hospice care that they will talk about those forms and help you fill them out.
They will.
Absolutely.
Yeah, and usually that's either through the medical director for palliative care or hospice care, or it's with the primary care physician that recommended you to them. But all of your primary care docs should be familiar with these two forms. Should be familiar with these two forms. I'm not going to say they will.
So
We keep them on
you're
hand.
saying, even though you had that golden form filled out, you need to have a pink form filled out too?
No, so the golden form basically is they come through the door and they say stop, do not resuscitate, they not going to resuscitate you. Now they may take you to the hospital if you're still breathing. You know, but they're not going to push on your chest, and resuscitation, the way we do it now is a bit
Some
different.
of them do it anyway.
Not if they have this. If they see this, no. If they didn't see it, yes. This one here works exactly the same way. So they are interchangeable in that sense, but this one goes further to say, what is it that I do or do not want once I get to the hospital? I think this is also a great discussion, honestly, to have with your family members.
I think the family needs to be there when you do that.
Have the discussion, talk to them and say, this is what I want. Because when they come back and they say, I know Mama said. How many times do you think I've heard those words? I know Mama said. But I can't. I can't live by her wishes. And I said, well, I'm sorry. Those are her wishes. That's what we're going to follow. And I've got a document then that I can point to and I can say, look, your mama did not want this. You're not going to do that. But yes, we did that too. I know, Mama said. But I can't see not feeding. She's not seeking out food. You're thinking in other terms. And one of the things that I will say as we kind of round this out back to dementia is at end of life, there's a few things that end up happening for the dementia person. Okay? In severe dementia, they forget how to do a lot of things. Even using a fork or a spoon. They forget how to do it. They forget how to operate even basic equipment, brush their teeth. But also, at the end of life, that person loses their sense of taste and sense of smell. And we know this because they've done plenty of studies looking at the areas of the brain, and they'll hold something up to the person's face and look at it on this big MRI machine to see what area of the brain lights up. Those centers don't even light up. It's not there. So imagine if every time you went to eat this nice big chocolate brownie with beautiful icing on it, right? I am chocolate free. And it tasted like cardboard. Would you want to eat? The other thing that happens is they lose the sense of hunger. Okay? Being hungry, by definition, is seeking out food. They don't seek out food. They don't. They're not hungry. They're not seeking it out. So, stick that tube in the stomach, you're force feeding them. They're not hungry. The only person you're making them feel better is you. So, point being, have that conversation with the family members. Help them to understand what your wishes are, because when the time comes, I personally can't think of a greater gift that you could give them. And that is the power to understand how you feel about it. Maybe the toughest thing for them to swallow, but it's still a much better place than having to make those decisions for you. Been there, done that. And I will tell you, it was one of the toughest days of my life when I had to go to the cardiologist and say, this isn't working. We've got to talk about our end-of-life wishes. That was a tough day. But I was empowered to do that because I knew what they were. So thank y'all so much for coming out for our series. We'll hang out for a little bit.
And
also,
as a plug, I'm Philip in the Living Last Supper next week at Christian Lutheran Church down in Granite Quarry, and I can't wait to perform. Actually, I dread it, but y'all need to come see me down there. I'm going to be Philip. So anyway, I'm going to drink wine and break the bread.
There you go.
It'll be good.
And Branson, thank you so much for coming out. We greatly appreciate it. That was awesome. Yes, sir.
I was there a little bit late.
Yeah.
I didn't get his name.
Okay.
I got a card. Come up.
Make sure.
I'll be here.
Well, I'd like to thank both of you.
Very welcome.
Very informative.
And Nathan, thank you for making that contact. Certainly appreciate it.
Fix the title in between the morning and the afternoon, because I gotta fix the title so
Shut it off.